File an affidavit. Bringing that annexure and mentioning it. Right? Request me. 10.
May I pray for listing of the motion method today itself? Transfer method, you know. That's why. There was some development took place. I have represented. Then you know the election commission put me in another place. You know. Now the authority is also pressing me. You know. I'm in a frequent situation. You know. When he sees a cancer patient. In fact, your lordship order is there in similar cases on deeply.
Family pension. Monday.
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 Okay.
Item.
What item?
Please. Yes, but
There is the urgency already declared by the
yes, yes, I think so. Yeah. Tough. Yes. Hard people.
So, do you?
Pardon?
17.
7.
My lord, that side, my lord, while they are reading the opposition at first.
17 Mr. ऐसे आ गए council. File. On behalf of the state. Second week of May. Like 29. Like a little louder. I think it's I think it's file. ABT for
I pray for listing or admission next week.
Your Lordship, I beg to mention audit petition matter 100/125 The last order was on 22nd October 2025.
For admission,
Then we yes, Your Lordship.
4th of May.
And Your Lordship, we had also approached the registry twice.
We are giving you the early date. For
Fine.
admission, motion, orders, when was it filed?
30. 30.
30.
Retired from service on Lordship 31/12/2018 as per surrender. After his retirement, Lordship, though all the benefits, retired benefits have been released to the petitioner, Lordship, but the GIS amount of rupees 70,929 which has been sanctioned by the authority on 7th August 2019, Lordship, that has not been released by the respondent authority. In the last occasion, Lordship, the respondent authorities, Lordship, when your honorable court sought for the instruction, they instructed that Lordship, they need Lordship all the statements of monthly subscription of with TV. Lordship. A retired person who served to the state since 1979 to 2018 and has been retired from service in the year 2018, and after his retirement, Lordship, the person who served 2 years district of the state, Lordship, now only for 79,000, Lordship, which has been already sanctioned by the department and only yet is that amount, Lordship.
When sanctioning order?
Your Lordship will find at page number 19, Lordship. Sanction at page number 19.
To release this amount.
Lordship, the amount is to be released by the only treasury, Lordship.
Have to be found.
It has been already forwarded as per treasury was also communicated, Lordship.
It's fine. Okay, instruction was used.
Can it be on our witness?
Are clamoring for release of payment. Last day.
I have some questions.
Then we have it after vacation.
One
Better be
six, Lordship.
listed, better be
Six,
listed.
Lordship, I can.
6 is not possible for them. Tomorrow is the holiday, Saturday, Sunday. Have it on 20. Immediately after the finance department.
So here the promotional appointment, my lord. District level committee, my lord, has selected case 33. The mother of the petitioner died on 9/9/16, and PLC sat on 29/4/17 and promoted the petitioner in case 33. Ganesh Kanan, grade 4, 10 men, that vacancy position of the F2. Then, my lord, to send to SLC White, there, my lord, held on 27/11/2020 after 3 years. Page 45 is the finding. And their first wife of their father, but the second wife of their father and son and daughters of the second, their name included in the destined certificate, and client has been attempt to show the entire terminal benefit depriving of the that is their given.
Next of kin, where is the next of?
Yes, ma'am. The next in
Where
of
is-
certificate that has also been
Where is
included
it? Annexure.
not annex, but because we have not been furnished with. And we have pursued the authority. I have made a statement in paragraph. My lord, paragraph 8, my lord. So, my lord, in paragraph 10, sub para. We have asked for the next in certificate, but that has been denied. My lord, that this notice may go, my lord.
You have asked for whom?
My lord,
From whom?
my lord, we are the son.
We have
daughters.
understood. You have asked the next of kin certificate from whom?
My
Who
lord,
have you
my
applied?
lord, whatever copy they have obtained, my lord, my stepmother, they have obtained a next in certificate relating our name, my lord.
That's right. Have you applied before the
My lord,
office of
we
the
have-
DC?
We have not applied, but we want to see whether our name is
Unless
there.
you apply, who is going to show it to you?
But our grievance is that they are likely to be deprived from the terminal benefit.
It's the High Court, the authority to issue the next of
My
kin.
lord, we have made several representations.
Where is that representative?
My lord, next, sir. We have made, 10 is the representative to the Assistant Director General of Police. My lord,
Next of kin certificate is issued by which authority?
we approach for the
Apply before the DC. Ask for a copy you already has. You know, apply for the next of kin
My lord,
certificate.
now our apprehension is that the entire terminal benefit is
apprehension-
going to be
Your
disbursed.
apprehension cannot be decided in thin air. Need something.
My lord,
Hmm?
my lord,
Or
our
is
apprehension
there
is
any
that
document to show that you are the son and daughter of late so and so?
Yes.
Any document?
my lord, yes, my lord, we
Where?
have the documents, my lord. Our academic records, my lord. Kindly have a look at page 24. 24 is the high school living certificate examination of the petition number 1, and his father's name is written here. Father's name Mokshed Ali. Same is, my lord.
Whether it is the same person, 10%. All these things can happen.
NRC also, we are, our name is there with my father. NRC, my lord, is 28.
But the next of certificate is not applied.
Not apply.
Why? You're not
My
paid
lord,
for cancellation.
my lord, in service group, our names are there.
Huh?
In service group of our parents, mother, our name is there.
Make the necessary application. We permit you to apply.
My lord, matter may remain, my lord, will independently apply.
Seven.
Well,
MSS Borua for state.
Okay,
C Borua for accountancy. A Borua for finance.
well,
Yes, Mr. Bose.
I want to point that without proceeding, without following 9(6), the Assam discipline appeal, without line following one witness only thing was not so. That's our point, my lord. Whether, my lord, without calling the witness based on only on his documentary evidence, whether it can sustain. That's the point. By your lordship,
State is the soil corporation department is soil conservation. We are not paying for soil.
They're not there. What can be done? Come and advocate.
Your lordship, the petition filed by the Olasa people, Manhattan and Association lordship, that there's a ATT lordship fine. So I would go directly to pay my lord 900 as amount of my lord all payment attendance of Assam. My lord, in that case, lordship, for non-compliance, contempt case was petition was filed, my lord. Various contempt petitions were filed, lordship. Now, your lordship will file, my lord, at page 140. Starts from lordship 140, lordship. The demand case, my lord. Order dated 17/2021. In that case, lordship, starts from paragraph 3rd, lordship. My lord, respondents, my lord, submitted the total 4,666 employees. The maintenance that had to pay, had to be paid, lordship. Now, at the latter stage, lordship, at page 143, well, an undertaking was given by the respondent by the Joint Secretary to the Government of Assam Health and Family Welfare at page 143, lordship. Herein, lordship, second pair, it is a stated, lordship, 1016, my lord, female attendants were, my lord, proposed to be paid lordship, and they were paid lordship. And rest were, my lord, undertook to pay the rest, my lord, as per law lordship. And as per law means, my lord, this honorable court had specifically directed to pay the female attendants, my lord, their honorarium lordship. So all the female attendants had to be paid lordship. Now only 1016 were paid lordship. Thereafter, my lord, the contempt petitions were, my lord, closed at the latter stage lordship. Now, the petitioners for 13 lordship, before you lordship, they have not been paid. That is, my lord, all Assam Female Attendants Association is their lordship. We are also represented in this case. Now,
What is your, where is your single?
my lord, all Assam Female Attendants Association at page,
Are you name?
my lord, 144.
One
My lord, the associations, my lord, the petition.
association.
We are also represented by the association. We are also represented by the association.
But we are not.
Not paid.
specifically named in the file.
Now, this honorable, the judgments of this honorable court lordship, my lord, in a writ petition was dismissed by the now single judge lordship, and the writ petition was written bill was filed challenging that lordship. The honorable judgments has disposed of, my lord. The respondents undertook to pay their honorarium, my lord, and the honorable court, my lord, expressed the expectation of paying the honorarium. Then, my lord, their payment directed lordship to pay 10 days lordship.
Directions are issued with respect to
My lord, the other, my lord,
other female
lordship.
Now,
Orders are there.
according to there is a direction to pay. While the contempt.
Yes, no.
During the contempt, some people were paid,
Yes, no.
then contempt will close.
The respondent undertook to pay their, my lord.
Where
honorarium
is
as per
the
law.
undertaking? Where is the undertaking?
My lord, at page 43, lord. 140. Their communication is there. The copy was under the 143. 143. Annex up. My lord, second, last, second, before the last paragraph. That on other hand, serial number 2. Who is lordship? Respect to others. Actually, all the female attendants were represented by the association. Sir,
They're pending in the finance department.
I'm to put it to one.
Yes, no. We are doing it. No.
They'll say the association will pay.
Then we are considering their case also. So, at point number 4, lordship, subsequently payment of rates of female attendants will be done as per rule. That is perhaps only for those people who are the contempt petition. get notification.
One week.
Permission of the learned council may be notified, that council may be that notified, undertaken, taken, my lord.
That is not been for the respondent. It's been for
Yeah. Prolonged suspension or not. Arrested in connection with it and it was proposed was issued to her on 30/11/2023. Diploma.
This was in 24. All recovered. Already recovered.
Therefore, my pension has been finalized.
All right, then it comes to party. Item number same. Where you want to name? Huh? I think that is 12 only. 13.
Diploma.
And, uh, and, uh, 10 on that data. 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 And, uh Better filing her application. And it also had it beyond 2.5. Their cases, my lord.
Regular methods.
What happened in this case? Sir was posted, present place of posting on 24/10/2024.
Where is that order?
Page 18. 1 month, home district, my lord, 1 month and
Where is
1
the
year
name?
and
Where is the name of the petition?
my lord name figures page 22. Serial number 76.
76.
Then my lord PCI guidelines where page 25, my lord, relevant person clause 7. Categories of officers not covered under transfer policy. During an election, a large number of employees are drafted for different types of election duty, and the commission has no intention of allocation of state machinery by large-scale transfer. Hence, the aforesaid transfer policy normally not applicable to the categories of officers mentioned below. Clause 3, my lord. Officers appointed as sector officers, zonal of ministry involved in election duties are not covered under this section. However, this observer,
Where is that order?
yes, my lord. My lord, page 34. My name appears page 35 as sector officer. Page 35 of my Anwar Hussain.
Pass.
Yes, my lord. That is there.
There is no illegality or
But he is sector officer.
sector officer, but not because there is a home district.
Huh?
The home district, he is at present working in the home district only.
No, but 7 is itself.
7.
Let me come to page number 34. Appointment order is 1 March.
Yes.
However, the transfer order is of 15th March.
On that, my lord. On that, my lord, lordship kindly see. There is this starts with in supersession of all earlier order BL number so and so dated 21. It was appointed on 21/2/26.
That supersession will not supersede your transfer.
My lord,
Uh,
that
is the transfer
if
order-
necessary, I'll place before your lordship what happened, my lord. Initially, he was appointed as sector officer on 21/2/2026. Before that order, then it was my lord modified in my lord 21.
So it was brought in on by the supersession of by
That order,
the transfer order issue.
this is an order issued by the first order. Partition order was election commission order. That I'll be on Monday, my lord. By additional.
Bring it Next, my lord, 36, my lord. An order was also passed pursuant to 15th order, 15th of March, and page 35. Page 35. My lord, the impending order, my lord, election commission order of 15.3 and transfer also 15.3. My lord, order 31, page 31. Page 31. My name appears in page 33. The pass of my lord 15.3. That is page 36. Number 2. Any instructions?
Not covered under the
They can be transferred. Should not.
as per the ninth guideline,
Seven.
ninth step,
Clause number 7.
they are not covered.
Further, is 35 not correct. Then the 15 marks because including purpose of the jurisdiction to answer this. All heads of the department about the are hereby instructed not to release any after them on transfer from the district level for the underwork without prior permission from the undersigned and the election commission. Maybe permission is there. Maybe permission is there. You know, only say without any
Maybe your instruction?
Yes, Monday.
Monday. Monday. That no instruction cooperative department has to brought in because all of you, if there is anything, you give What will you find? Seven is infractor.
But
Also infractor.
first PQ was issued item 37. But
Similarities are good.
PQ was issued only against Malak 37.
Therefore, 37 is infractor.
37.
Okay.
Sir, my lord, case number 61. Event of service of the PQ. File an affidavit.
Affidavit file.
No, no, sir. One point of delay and necessary option is pointed out. There are certain other restrictions from the similar ground, wherein delay and by your lordship. Just paying for some time. The other matters may also take.
Filing.
There are certain other restrictions from the similar ground. So one affidavit for all.
So we are giving unless you point out that filing an affidavit filing.
Point of maintaining the filing.
don't know what to think. Pass over on the basis of item 37. Finance.
For item 37, the trading of the directive.
Say it is intractable.
That's all, but if you send to them as a treasury, but not thinking of it, treasury.
Pass over.
Not for
Thank you.
that a list of casual workers along with the has been compiled and sent to my finance department for consideration.
Mr. Rai Bothakur.
After that, my we have not received the complaint from finance. I take update.
Status of the price.
Still party is concerned, Manga, but wants to clarify on that aspect also. done any work construction that has something has been created. But because when space was deducted as source window, and the assessing authority asks to submit papers window so that assessment can be made. And if he has any problem, immediately after view.
Something.
In respondents,
He said it's for the law.
what else is
Like very clear, not to apply to pending food. The pending food, then not. Earlier there was order, then they are still occupied with food. That one of the yes, we all accepted and following. But in so, yes, they will. Thereafter, this which order? Not general. Lot but order would be. Respective is reflected lot in the order.
First, that we will appoint, but then we, now, what we have is.
Audit, my lord.
What are
None.
we pass orders?
I'm
Okay. All the four matters.
all the.
Affidavit was filed or last time something like that.
And then affidavit.
This is filed on 18 March.
That's right. Yes.
What is the,
That's how this post has got sanctioned in place as a promotional post. After the modification of the recruitment. 17/6/2020. It was a direct recruitment post. At the time of when the selection had taken place and 4 persons have been selected and appointed and petitioner was in the waiting list. At that relevant time, Lordship, this post was existing. It was existing from 2021, but it was a direct recruited. A promotional candidate not be entitled to this post. His name is in the waiting list, number one.
how a post is sanctioned? But what is the process for sanctioning? Calendar year of vacancies. Except those posts which are freshly sanctioned. But you are trying to project this post which after rearrangement of the roster.
Yes, after
Came to be available for the promotional. Promotional post. You are saying that this is a freshly sanctioned post. Now,
got
how,
freshly sanctioned.
how are posts institution sanctioned? What is the process by which a post is sanctioned? Sanctioned means how do you find a sanctioned post? Does it mean that it has to be freshly created? Does it include what you're trying to say that posts are there, but it was meant for, was required to be filled up by two different sources?
That is exactly. That's why I have stated that 2020 or not, 104 BOG.
You have stated it. How define a post to be sent? How do you identify question relating to sanction of post? Now, let us say in a government department, for a post to be sanctioned, there has to be a proposal, normally, that post is required to be sanctioned. Finance will require. Yes, yes,
Understood. Get a question is that this post vacancy has been existing from 2021. Because it is
therefore, does it meet the operational sanction post?
no, Lordship will come to that. But that time, only 4 posts were available in a promotional quota. But this
That is what is to be available.
what's available, Lordship? Yes.
So, there are sources of support. Sources of support. Whatever.
According to roster.
But
Who define rosters?
those posts are only there. Five posts available. The deep stuff.
That's what my submission is.
No, your
That by
Yeah.
operation of law,
you
you
have
consent.
understood your support.
Got it.
Support. Should be available. This is the appointment. Makes it a sanction post.
My submission, Lordship, is this. The by operation of law, the change of the law, this process automatically come to the promotional post. It was from the roster, direct recruitment
That's
roster.
what we are saying. The post was already in existence or to be filled up by direct.
The vacancy is continuing. But that vacancy is meant for direct recruitment. While the selection had taken.
That's not what you say. Exactly. Sanction post. This sanction post. Sometimes vacancy.
sanction for the promotion roster. It was in the direct roster. It was in roster direct appointment, but because of the
That-
change of the law,
Lord, sufficient to understand.
Got
Ask me. This is for me.
because the amendments that had taken place has been approved.
Yes.
Because the amendment was approved by the BOD on 16/6/2022. Once that amendment,
Mr. Council, not one your system in that respect. Category A, travel category Y. Therefore, in your understanding, the fresh sanction for departmental. One aspect. We are asking you that there is a circular by the government. There is like interpret that these kind of available by real it also that is the practical sector so far as the promoted.
yeah, the question of vacancy, that's for the vacancy. The vacancy has come.
Question is not a vacancy, it's
Got
a post. Kindly see your rules. The rules are very categorical. 6.2.3. Sanction of posts. Doesn't talk about this.
Yeah, no. That is in the advertisement itself, general information.
No, this is the rules for it. 6.2.3.
It was picked up in the advertisement. Yes, now. Then it says that general. At page, Lordship, 99. Earliest circular, 5/1/22. The general information, the rule has been quoted like this. Number 3, panel, bracket selection, public waiting list, drawn up by the Department Promotion Committee as per Government of India norms, is valid for 1 year.
You're reading to
At page 199.
90.
Advertisement dated 5/1/22. Generally, first, panel selection of the waiting list drawn up by Department Promotion Committee as per Government of India norms is valid for 1 year. If any post falls vacant within 1 year of the DPC making, they will be filled in the waiting list as per category. That means that it goes to the roster order. It will not apply for fresh sanction of post made after the advertisement. Candidate selected as per the recommended. It will not apply for the fresh sanction of post made after the advertisement. Here is got to consider the category also.
That's what we're saying. We're operating sanction vacancy.
Saying that the vacancy exists. Falls vacant within 1 year. If this post falls vacant within 1 year, these posts we are talking about now, that issue that has been lying vacancy in 2021, even prior to this advertisement, because it had fallen the direct recruitment roster, it was not listed. Post falls vacant. Thereafter that within 1 year, it has already just lying as vacant post. Even prior to the advertisement 5/1/20. It was lying from 15/4/21, the post was lying. But as we belong to the direct recruitment post, it was not disturbed. That the circle is for 4 posts of promotional post, not for direct recruitment post. This post has been lying vacant prior to that. But it belongs to the direct recruitment quota, where it is as per here, this is already filled. This was not advertised. This post, but it belongs to that. The time of lordship that selection had taken place, where my landed friend's client appeared, got a waiting list, selected waiting list at that time, and subset to that thereafter. In June 2022, there was no vacancy, no post. That promotion list. Only one post which is lying vacant prior to the advertisement, that belongs to the direct recruitment quota, to which the petitioner is not entitled. Now, after the amendment of the rules, the quota that in the promotion post has been raised for another vacancy that come. And the direct quota was already filled up. Therefore, because the change of the rules, this post has been converted, automatically converted into by board of board decisions to promotional quota. But petitioners, right? Is that is the lordship.
What is the post? Instant register.
Extend the lordship. Now,
How many posts were there? 4.
the 4 posts were there, but it has been raised to 8 posts. Total posts are 16. But the quota has been raised to 8 posts.
Yes. And we
Second advantage.
5-1-20.
5-1-20 to 4 post no advantage. No, 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 no. But the question is, if a vacancy arises within that vacancy year, the vacancy arises within that vacancy year, that is before 31st of December, then it has to be given the wait list or whoever on the top of, depending on the number of. Instead of that, they thought about that for direct recruitment one. Now, so for a sanction is necessary, in my so only to clear that point, my written argument is there, was submitted during the last hearing. There, para 14, how a post has to be sanctioned, how that proposal is my written argument. Para 14, yes, internal page 12,
This is as good as another repetition. Why?
at that time. There are 14. There are 14. May I just read, the since the respondent IITG has already admitted that the post in question was the newly sanctioned post, and as such, it is incumbent upon the respondent IIT substantiate its own stand on the basis of material of record, show that the post in question was a newly sanctioned post. It was their argument, initially in the preliminary ethics. It humbly stated the requirement necessary for sanction of a post in the IIT entire area. Recommendation of the resolution by the Finance Committee of IIT and approval thereof by the Board of Governors. Thereafter, clearance from Ministry of Human Resource Development and clearance by the Ministry of Finance. Whether these criteria were met in the case in hand can only be ascertained from the concerned records, which were called for the response, but unfortunately, records never came. Either they don't have or they are, for some reasons, they are not ready to disclose it. Now, your lordship will kindly come to page 37, annexure D. This is an instant, but to give credence to my this argument. Page 37. A simple thing, my lord. Redistribution, if they say that is the sanction, then 16 plus 1, it has to be done. The number of posts remain the same, 16. Even now, let them deny. Your lordship will kindly come to page 37. Fine. Seven. Yes. Item number 4. Item number 4 is the
7 is office memorandum 27/3/2020.
page 37. Yeah, no, madam, this is dated 5/3/2007.
Part of the
Annexure D, madam, of the written argument. They are coming with affidavit. They are coming with affidavit even now, madam.
Is it a part of
Well,
primary pleading?
because my lord, the records were not placed by them. The relevant records were not placed by
So, right, but definitely.
done, my lord, because the matter kept pending for quite a long time. Then during the
We are
arguments, my
asking
lord,
you in written argument.
my lord,
Can the court look into these elections?
no, just my lord, only to drive home this point, but because they were arguing, my lord, that it was a sanction. Okay, this one, they have not placed the relevant records, my lord. How can they have to counter their arguments, my lord? I have to give something, my lord. And it is their document, my
No,
lord.
you are entitled to give something. What we are saying is that why we written argument. Not it by way of filing additional pleading.
My lord, their written argument also.
They will say that you've done it, therefore they have done it.
My lord, page 36. We have not annexed any. Page 37. Annexed. Page 37. Recruitment of non-academic staff for each. The matter was discussed and deliberated in detail. The board noted the urgent requirement of staff increase. The board also noted that a proposal for creation of post approved by the finance committee and the board was pending with the Ministry of HRD, and the clearance from the Ministry of Finance will also be. Only to drive home this point, how a post has to be created, how it is sanctioned, man. Nothing else. Now that apartment, that is one way to look at it. And then my lord, page 20 of that argument. All these things have come from them, my lord. These things didn't come. They have not denied it. Page 20, my lord. Arguments. See, this was from the Ministry of Finance, man. Starts at page 19. The office memorandum dated 4/9/2022. Dated. Now in page 20, your lordship will find creation of post. There will be a ban on creation of new except with the approval of Department of Expenditure in ministries, stroke departments, attached officers, appointed officers, deputies, etc. Now this ban continued till 2024. That your lordship will find in page 20. When they had, my lord,
What is the effective trade?
my lord.
We are not challenging the private business.
No, his appointment I have challenged. His appointment I have challenged. Appointment I have challenged.
That's the building.
The appointment, advertisement was not challenged because I was not claiming. The appointment is under challenge. That is why the second petition came about. His appointment as also his approval. Approval of his selection. Yeah, well, kindly come to see.
Where are the records?
This is not happening in anarchies. Our posts have been sanctioned already. discussion also. At page Lordship 103. Allowed the amendment. At page 103, 101 BAG, 111 BAG. Now, here first item number 20. It considered board was informed the committee was constituted for modifying the rules. Now that board Lordship has recommended as follows. Based on the examination and observation, committee recommended as below. But in the same page you are PL number 1. But you can turn the next page, PL number 3. The distribution of posts. Posts are there already. We're not giving new posts. We don't take them in PL number 3. Distribution of posts between the direct recruitment and promotional. In case of entry level group A posts are inconsistent. Assistant register 75% is 25. Now, and the right hand side document in terms of the MICD data number data section, committee recommended to earmark first the post of assistant register by promotion. Just come to the promotional roster. So initially it was for 25%, but now it is by 50%. It's the same recommended by the committee. Now, because of that, new posts have come to the promotional side. Now, Lord School kindly see page 102 of 109, Lord School. The resolution. Last paragraph, Lord School. Board was requested to approve the recommendation of the committee as mentioned above on recruitment rules. Distracting some non-teaching posts. Steps towards pyramidical structure of posts across non-teaching posts and periodic review of the recruitment rules in a span of 5 years. Board was requested to approve the recommendation of the committee. Committee recommended that for promotional side there should be 50% and direct recruitment also be 50%. That was the recommendation of the board. Now the resolution was that resolved that the recommendation of the committee as mentioned above on recruitment rules. Restructuring the non-teaching posts. We are on the vacancy. Posts are only there. 6 number 6 posts are there. Section of new post. The vacancy. This is allotted from the one roster to another roster. Because of the restructuring of the posts. Posts will remain same. You are not creating a new post. Next also. In our last episode, you produced a bunch of reports. Cannot.
Are these photocopies?
No, we have original copies. We have placed the code that was missing. So they are certified photocopies.
That's right. We don't want you.
Yeah, lots of here. Lots that record will lots will find it in. Lots of that page. At page 33. Page 33 of the records.
One yellow one.
Yellow.
Yellow.
dated 24/11/22. So you can see initiation of internal recruitment process through promotion. Now the chart is given there below. As per record, following posts which are lying vacant. The posts are there but lying vacant are to be filled through promotion DPC. The details of the post is below. Number one, assistant register. But in the chart, it shows that total post 16, percentage of promotion 50%, number of posts for promotion 8, man in position 15, vacant post 1. So this is the that comes down below the chart, before another chart is there. Therefore, the competent authority will like to allow the initial recruitment process for the following posts.
What are these?
Fines, here the minutes of the document for the time being, like if it aside only maybe minute, not all the relevant posts. Relevant portions are into this table. Page 33 only. Put another chart below. Therefore, the competent authorities, the note 6 giving the different authorities may like to allow initiate recruitment process for the following posts. Assistant register, number one, assistant register, name of the post, assistant register. Total sanction post 16, man in position 15, total vacant post 1, direct recruitment 50%, promotion 50%.
Now,
Man in position is 11, but can
one, three.
but that the site is changed, but because they are competent, but they are competent everything. And then the expert committees giving the recommendations.
This is the part of your work, the statute.
So, Board of Governors, the state is also itself, the Board of Governors is final in this.
Have any
Statute is there. I just one thing I wanted to actually the chart says the chart right hand side remarks the below chart. The remarks is there as there are excess man in the position appointed through direct recruitment. 11 already there. Procedure. The one vacant post may be filled up through promotion. That was the remark given by the competent authorities and sought for of the BOG. The direct recruitment, they've got sufficient people and over. Yet, promotion recruitment, one post has come, there's no vacancy. So this direct recruitment post will be converted to promotion recruitment. And lordship, I have given a translated copy, lordship will kindly give my affidavit, lordship. Last affidavit, the translated copy of the note sheet. But the note sheet. Or type copy, the translated. Sorry, I'm sorry, lordship. Type copy. Thank you. Page number 171. Here. Page 172. That's a typed up lordship, handwritten notes. Under vision mode of recruitment out of numbers of posts stated at page 19 numbers are in page 19 numbers are in page those interview only, while the remaining 44 posts are through written test, that is directly. Out of these 19 posts through interview, roster needs there for 5 posts of section officer and RR needs to be used for the post of JTO cannot contain that officer. The subsequent line, they please advertise from, please advise permit on the further course of action and the following. Number one, initiate recruitment process for the post of air, estimation, and some other posts and other having interview. The down below also that HOS Head Department has discussed down below, continue on page 3, HOS administration. Discuss in principle administrative approval for start of selection process for the promoted post may be given. Thereafter, the vacant posts along with category STS as per the reservation roster can be placed for certification of liaison officers of STST report on security. Now the director is given order, process may be initiated, so process may start. Next page, Lord. After approval of the competent authority, as advised, circular has been prepared and placed below. Kindly be seen and forwarded for signature, please. Liaison officer can come down that latest possible. Director, approved for publication. 9/12 is the post which was advertised subsequently is converted into promotional post that was advertised and director has given this permission approval at the last post approved for publication. Thereafter on 12/12/22, this post was advertised, treating that as a promotional. Next. Yeah, next. The yeah.
What's the power that, power to create posts, not, specify qualifications, etc.
But let me conclude that we are not creating a post. The question of post have been created.
We want to see for ourselves, for our
Lord,
satisfaction.
yes.
What is the power
Lord,
in IIT?
I'm sorry.
Because you're a autonomous institute,
Lord,
although under the government of India. So you're not like a government department that will require sanction and approval of
quite right.
department.
Not correct.
So, but we want to see from your statute or act or
Yes. Kindly turn to functions of board. Section 13, function of the board. The act.
action using the general description, but why really? And you also have the powers to create posts, reorganize or specify the qualifications from time to time, etc. Must be some powers conferred somewhere.
Yes, state is got here.
Where is the statute?
Got it. Academic I just read out this para 13 is everything. Subject to Provisions Act, the board of any institute shall be responsible for the general superintendent's direction, etc., of the institute, not otherwise provided by this act. The statutes and the ordinance and shall have the power to review the act of the state. Without prejudice to the provisions, the act, the board may institute one take decision on which the policy, etc., be institute courses of study at the institute, make statutes, institute and appoint person to academic as well as other posts in the institute, consider and modify or cancel the ordinances. F, consider and pass resolution on the annual report, annual accounts, budget estimates, statement of development. Says exercise such other powers or that such as other duties as may be confirmed or imposed upon it by the Act. Board shall have the power to adopt such committees, senior for its take decision on creation of post and working of the institute. 13A logic it says, judge predicts to the provisions of subsection 1. Court of any institute shall take decision.
Okay, let me they follow the prescription of the Act. No. Power. Standards by not applicable. Such powers or you have the power, but subject to such criteria, priority, parameters. What extent you can exercise the power?
Yes, but minor qualifications. They have taken it as minor-
What bars they? Because they are still independent quality. They can take a decision in the midst of the
Assuming they have the power. You also kindly come to page 37 once. Or by read it's 3937. All value lowercase b, small b. I'll read out. Part of that rule 4491. The officers who have already empaneled or placed in the extended panel but not be promoted due to these vacancies not actually becoming a cases by the supplementary cases, the assessment matrix remains the same. Those in the wait list. You'll also see as the assessment matrix remains the same, meaning that assessment matrix for that year will not change. Now, why not your logic will kindly come to 500 advertisement. Kindly come to that 51202 at page 27. Why not
general information clause 1. Cut-off date for counting experience is 1/1. Now the second advertisement. At page 33, man. C2, man. General information in the Lordship kindly come. This was published on 12/12 of that year, man. Second one, 12/12/20. Now, my lord, general information in the Lordship kindly see. 1. Cut-off date for counting experience 1. So therefore, my lord, they could have changed, my lord, even assuming they have power, the supreme power, they could have changed it. Because the DOPT guidelines not suggest that. And number 2, by their own document, they have kept their experience. And my lord, besides, my lord, the petitioner himself was qualified, man. He was allowed to take part there, my lord. If he did not qualify, man, I'm not qualified. Why would he be called for the interview? So that argument will go, man. That are no basis. My humble submission, my lord, they have, even if they said in their preliminary affidavit that it was a newly sanctioned, and thereafter they qualified themselves to mean that it was a result of redistribution of votes because of that office memorandum. In any case, they have failed to show that it was a newly sanctioned, and therefore, that vacancy having arisen within the vacancy or within 2020, that should have been given to him. Should have not been petition. Was placed at the top position of the vacancy. Now, my lord, will kindly come to the last occasion or the occasion that, my lord, I have placed the photocopy of the recent advertisement issued by them. Now, what they have done, my lord, in spite of their submissions made before this honorable court, and with little, my lord, can respect the pendency of this case here, they have come out with an advertisement, my lord. It's a online applications from eligible Indian nationals are invited for appointment to the following assistant registrar to post. This is for direct recruitment. My submission is that, my lord, when if they have a vacancy, they should have adjusted this because, my lord, on 26/3/2005, they promoted one Lobono Kishore Kaur, assistant registrar and, my lord, to the post of vacancy. That post fell vacant. Issue or was promoted as deputy registrar on 20/60/25, and that means, my lord, one more. My lord, I can place it, my lord. How, my lord, after one hearing and thereafter 1.5 years, my lord, another hearing. Now, my lord, bring all these things. Well, I can only place this, my lord. In the deny it, if they want, I will serve them for this, my lord.
Like that. You're relying on the.
My argument is this, my lord. My lord, what is MSC? They
Now,
have
what do you
already
say-
appointed, my lord. Here is a case where the petitioner has, my lord, his rights have been taken away, man. It is not a question of vacancies there, they do not want to fill up. That is a different thing, man. Here is a case, man, where the vacancy is there and he is entitled for that, be promoted to that post, and he is not given there. Instead of that, they are bringing in another advertisement and bringing the private respondent. So that is the case. Hopefully, my lord, it should have been given to the petitioner. It is as simple as that. And now again, my lord, thinking that nothing will happen. So they have come up with an advertisement for direct recruitment of promotional. Not really, my lord. What will go, my lord? I have to be adjusted somewhere, my lord. What my argument was this, my lord. Your lordship has said an affidavit, my lord. Perhaps an affidavit is maybe necessary, but actually I don't want to accept any number of times it has been listed and on number of occasions your lordship then your patient period. My lord, he is appointed. I have challenged his appointment. But since Lobono Kishore has been on a later date promoted as deputy registrar, that post is vacant. That post then he can be adjusted. The private respondent can be adjusted against the post falling vacant on promotion of Lobono. So my post on that day at the release of the week, that post can be given to. Once an affidavit, my lord, I can bring this facts on affidavit. But in my humble submission, they have utterly failed in their efforts, man, to show that is a need sanction. Number of processes remain the same. There are redistribution, sanction, no sanction, they remain the same. 16, man, their own documents. Why does it?
I've got some decision to place on that waiting list. Got us immediately help.
Prior to that, my lord, the tendency of the my lord, that first they need to election of the private and appointment them, so therefore the second.
What are you telling me?
And I claim that post, my lord, on the basis of my knowledge. That yeah, my lord.
Yes, what judgment? What?
Son of right. They kindly turn to para 12. By considering the entitlement of the respondent to any relief on the basis of his placement in the reserve panel, it will be necessary to bear in mind the settled position that mere placement in the wait list does not create any vested right for being so appointed. The right to be considered for appointment spring only the contingency of a selected candidate not joining on the post. Wait list operates for the limited period, cannot extend for the indefinite period and any event after fresh process of recruitment has commenced. And in any event, after it is clear, this legal position is well settled in the reference can be made to the decision of the three judges bench of Gujarat versus state of Gujarat and others. This decision, para number 9 is quoted here. It has been held as under para number 9. Waiting list prepared in the examination conducted by the commission does not furnish as a source of recruitment. It is operative only for the contingency that if any of the selected candidate does not join, then the person from the waiting list may be pushed up and be appointed in the vacancy so called, or if there is some extreme exigency of the government, may as a matter of policy decision pick up the persons in order of merit from the waiting list. But the view taken by the High Court that since the vacancies have not been worked out properly, therefore the candidates from the waiting list are liable to be appointed does not appear to be sound. This practice may result in depriving those candidates who become eligible for competing for the vacancies available in future. If the waiting list in one examination was to operate as an infinite stock of appointments, there is danger in that state government. There is danger that the state government may resort to the device of not holding an examination for years together and pick up candidates from the waiting list as and when required. The constitutional discipline requires that this court should not permit such improper exercise of power which may result in creating a vested interest and perpetuate waiting list for the candidates of one examination at the cost of entire set of fresh candidates, either from the open or even from service. Waiting list is something there candidate entitled to those posts where selected candidates are appointed. Some consider a PhD decision Lordship I have annexed here. It's very clear that there's been you just taken a decision on these posts. Kindly Annexure 1 or item 13 of the under the 15th POG decision taken when waiting list would be applied. So candidates, the rights of the candidates waiting list at base Lordship. I think base Lordship 170, Annexure 1.
170.
170 Lordship. My last update. To follow the DOPT guidelines for the preparation of the recommendation of the extended panel of selection. Board was informed that an SP dated 24/5/23 has been received from Mr. Surendra Mohan Saloi, Deputy Secretary, Senior Superintendent of the Institute, requesting for reconsidering him for appointment to the post of assistant registrar from the waiting list, which was valid for 1 year and approved in the 103th meeting of the BOG on 31/2/2023. In the appeal dated 24/5/23, Mr. Saloi, Senior Superintendent, Stores and Purchase, stated that having somehow managed come across BOG's minutes dated 31/3/5 such item number 13 today, he has no other alternative but to request competent authority to offer him to the post of assistant registrar by BOG approved panel, which as per the minutes of the that BOG suspension dated 31/3/23 remains valid up to 18/23. He also stated that the advertisement by number suspension dated suspension was not only illegal but violative of IIT BOG's directive, which the first place should not be there. The agenda of the meeting in the situation events salient points leading to the advertisement of 4 assistant registrars by suspension dated 5/1/22 and press advertisement by circular number suspension 12/12 dated 12/22 is summarized, and so the extract of the agenda is given as item number suspension. So to avoid unnecessary confusion, it is proposed to follow the DOPT guidelines that are 9/4/96 of extended panel by the DPC as follows. This DOPT guideline, Chapter 1, when persons included in the panel have permission on alia occasion and under debarment of permission, or in this case, the person who is selected, he refused permission in earlier cases. That case, the waiting list can be considered. Second, Lordship, when officers including in the panel have retired or are retiring within same year, it is selected candidate retired to then only, Lordship. Number 3, resultant vacancy due to regular long-term promotion. The board is requested to consider the proposal. But only 3 cases waiting list candidate can be appointed. Firstly, the candidate selected, they refuse promotion earlier year or some God is there. Second case, Lordship, officers included in the panel have retired or going to retire. Then the waiting list can be put in that place. Thirdly, the resultant vacancy due to long term means someone candidate will be selected for the appointment. Therefore, has gone for long leave or long term promotion somewhere else.
The regular promotion.
Board discussed and resolved as below. Resolved that the institute shall prepare limited and reasonable wait list extended panel by considering the number of persons included in the panel who have refused promotion. That the person refused promotion on earlier occasions and under debarment of promotion. Number 2, vacancies to be created by retirement in the same year. Number 3, resultant vacancy, regular long-term promotion within the same year. Only these 3 cases, waitings can be considered for appointment, but those again selected posts, not for any other post that will come. But this is also discussed before judgment. That's all.
My case might be the third situation.
And he represented submitted by the petitioner.
He was promoted, so that
Was considered by the BOG and rejected for these grounds. Now, secondly, that's resultant vacancy, regular long-term promotion. Regular long-term promotion. That's the done here. Resultant vacancy. The same as the person selected must have gone for some other promotion, also long-term promotion, the same year.
The beginning,
For selection,
vacancy.
the only meaning. The only thing better from here. Certain vacancies occurred, long-term promotion.
Qualify the term regular, some regular rule, not short term rule.
Exactly. During this case, my lord, at the relevant time, one. I just got to point out one thing. This OM of GOP, thing right upon by the petitioner, as a stone backbone of the argument. The present case, this OAB was dated 27 March 22. The at page 36, petitioner annexed that OM of the GOP issued by the GOP. And
36.
on the page 36. OM was issued on 27 March 22. Whereas our advertisement is on 5/1/22, selection are taking place on 18 to 22, and the appointments are made in 31 to 22, long before the OM was issued. How can this OM be logic? Divide up. Why did it? For this, everything has happened before the OM was issued. Kindly come to page 37, my lord. My learned senior friend has overlooked the statement. Kindly come to page 37 and then it will clarify. This was a reiteration of an earlier memo of 1989 and 2015 that is mentioned at the bottom of my lord, that was that rule 4.4.91 at page 37. Very
What about clause 1, page 27? What category, under what situation this clause will be
vacancy
applicable?
time of facts and materials before the DPC. Such cases, another meeting of the DPC should be held for drawing up a panel for these vacancies as these vacancies could not time earlier. When they affected this redistribution, on that day itself this post was vacant. So this was not an unforced.
Being there, but vacancy not being filled up.
Doesn't have to be created. Vacancy falls.
Because vacancy.
But here is no process created, man. 16 number of process within 16 months.
Correct. But this.
That post was vacant. Man.
But the rule say, if that falls vacant, the rule say,
That particular day,
they were 4%.
subsequent rearrangement. Vacancy.
Quite clear, man. They by this is their own, they are placing, man. Hard situation. The person is promoted to the next higher post, deputy register. So that is a permanent regular promotion.
That those are not part of the field.
Madam.
When every certain vacancy.
No, madam. What I'm saying is that what they have to follow, madam. And if the vacancy, I'm saying, madam, that vacancy arises, then it must be given to the, and the cross 3 will cover my case. They are document that 23 document they have just placed, madam. This,
Any argument they
madam,
heard, we heard. Any judgment,
yes,
Mr. Kakwati,
refer 3 judgments. That's okay.
name missing don't. Adaya. Rajasthan judgment.
Yes, Lord, so the state of Rajasthan.
Yes.
It is the law. Most at the time of occurrence will be full. Here, the rules. Time of vacancy occurs. This vacancy is in a promotion cycle occurred.
Not only hear it. Some qualification. Criteria.
The main criteria.
Now the question would that on the day when management goes to meeting. After this,
Related to the restructuring of the positions. Restructuring has created a vacancy in the promotional quota, which is earlier existing in the direct quota. That's why.
The first one is on that minor word sanction minor. If it is unambiguous minor, if it is clear from the provisional minor, then we should bring the following meeting. On that minor, I am placing my reliance on 2003 Supreme Court cases 111.
Nasira.
No minor. I'll come to that later. Bhavnagar University minor versus Palitana Sugar Mills, paragraph 2. Paragraph 2. There is the basic principle of construction of scrutiny that the same should be read as a whole, and chapter by chapter, section by section, and word by word. The course to construction or interpretation of statement is necessary when there is ambiguity, obscurity, or inconsistency therein, and not other. An effort must be made to give effect to all parts of the statement unless absolutely necessary, no part thereof shall be rendered certain. So this is on the sanction manner. Sanction cannot be redistribution or anything else, man. Sanction has to be sanctioned. It should go by the simple meaning of it. That is one. And 25, man.
Yes.
Scope of legislation on the sanction of legislature cannot be enlarged when language of the provision is plain and unambiguous. In other words, statutory enactment must ordinarily be considered according to its plain meaning and no word shall be added, altered or modified unless it is plainly necessary to do so to prevent a provision from unintelligible, absurd, unreasonable, unworkable, or irreconcilable with the rest of the state. These two paras, 23, my lord. And my lord, Najiram. If something is to be done in a given manner and that has to be done, not at all, man. Page 512, man. I've given a copy. Page 512. Paragraph starting with, my lord, put is contention. 512. Which applies is a different of less well recognized, namely that where a power is given to do a certain thing in a certain way, the thing must be done in that way or not. And my lord, in reply to my friend Mr. Mohanto, my lord. Time and again, you had argued, my lord, one cannot, my lord.
In anticipation of the
No, but being unsuccessful, I cannot, my lord, that is the rule, my lord, but there are exceptions. I cannot challenge the
what
advertisement.
is the Assam judgment?
Oh, that is an old one, my lord. Respondents cannot take advantage of their own wrong. Paragraph, there are 13 men. My lord, this is the Raghava Raja Gopalacharya. You have to find out. 1967 SCC online. And our, my lord, the whole books for Assam and Nagaland, it was something like 1971 or 70. Here, my lord, paragraph 13, man. Last page. Challenge is such petition when it be completed file visit. Responding. As you know. And then, my lord, is the one. Or Mr. Mohan. Major Mita Sahai versus State of Bihar. 2019, 20 SCC 17. Paragraph 17. However, we must differentiate from the principle insofar as the candidate by agreeing to participate in the selection process only accepts the prescribed procedure and not the illegality. A situation where a candidate alleges misconstruction of technical and discriminating consequences arising from the thing cannot be merely because a candidate has partaken in the constitutional sacrosanct and its violation in any manner is permissible. In fact, the candidate don't have locus to assail the incurable violation of the provisions of the Constitution unless he should participate in something. And my lord, by filing successful and my submission, my lord, that the records, my lord, which were actually called for was never put. I myself have submitted. I have, but they have access. They have access, I don't have access. No, let it go, madam. I don't gain anything, but there's nothing, madam. Madam, so far the point I have raised. It doesn't say anything about press sanction of the post. Yes. And my lord, that his appointment I have challenged.
Not challenged.
Clear, my lord, my prayer is clear.
And I'll come to that. Because my lord, during the pendency of the after I have informed that I have for my affidavit, my lord. In fact, my post was also confirmed, my lord. Your lordship kindly, my lord, your lordship kindly see whole case is that he's taking the advantage of the clause 3 of the advertisement. That validity what will be for that effect, my lord, he has filed a appeal before the authority. The appeal was, my lord, clearly, my lord, on clear terms, it was disposed of. That has not never been seen before.
Send the order is settled, madam, before the.
My lord, he has not been finished, my lord. Let him finish.
Challenge, my lord. I'm saying it is challenge.
My lord, your lordship kindly see, my lord. I have preliminary objection regarding, my lord. Your lordship kindly see. He appeared in the interview, my lord. Knowing fully well that, my lord, after, my lord, he is not success, my lord, then only came to the court, my lord. My lord, when he not success, he filed a writ petition, and then, my lord, without challenging the interview, my lord, challenging the advertisement, my lord. Your lordship kindly see that, you know, and this post, which was, my lord, he want to take advantage of the clause 3.
Now,
My lord, I'll come to that. My lord, your lordship,
vacancy resulting.
my lord, this post was born to the cadre of promotion when? Cadre of promotion that after the board meeting 111. 111 board meeting, my lord. Otherwise, it is not born to the, my lord, cadre of, my lord, for promotion, my lord. For, my lord, appointment, it is everywhere. Appointment, anybody can come from all over India. But for the promotion, my lord, your lordship kindly see the it born to the cadre of promotion only after the 111 board meeting, my lord. That means, my lord, after the advertisement, my lord. She cannot take advantage of that, my lord. It is a clear position that, my lord, that post was born to the promotional cadre only on, my lord, after the board meeting. My lord. Now another thing, my lord, your lordship kindly see. And he for clarification, my lord, he filed a representation for that, my lord. That was disposed of by the, my lord, authority. And how it is disposed of, your lordship kindly see. Your lordship kindly see the rule, my lord. That, my lord, Indian Institute of Technology, Gauhati, Recruitment and Promotional Rule for a non-teaching position. That rule, my lord, rule 9 is very clear. That interpretation. Where any doubt arises to the interpretation of any provision of those rules, the matter shall be referred to the director director of the institution whose decision shall be final. Rule 10, my lord. Authority to resolve the implementation of the issue. In case of any difficulty and enforcement in implementing and provision of this rule, the director of the institution is the authority to resolve the same issue. So they have, my lord, already resolved the issue and giving a clear answer to their representation, my lord. So that is my submission before your lordship, my lord. That he is, my lord, not been challenged, but if he is not his representation, my lord, disposed of, because, my lord, he knows it. So it was not challenged before this honorable court. And moreover, my lord, during there is no stay order, during the, my lord, pendency of the, my lord, during before filing my I was appointed, I clearly mentioned this, my lord, my affidavit. There is no challenge to that, my lord. My lord. My lord. Promoted.
That vacancy,
My lord, he claimed.
that is in person,
Yes, my lord.
separate.
Separate DPC. It is independent DPC and they are independent DPC because in that, my lord, advertisement, my lord, that criteria is also only the finding is under silence, but advertisement is not silent. And qualification of the both the earlier post, my lord, which is claim, my lord, but this is this post, my lord, and that post, my lord, that is wide. Now, my lord, qualification is also, my lord, that is different in earlier advertisement. So that's why, my lord, without silencing the advertisement, my lord, and my lord, I place a small, my lord, an argument I can. And along with judgment,
You are not in competition with your counterpart.
my lord.
Respect to the
No, my lord,
will accept your
a small, my lord, because this is my version I have. I am not replying because his answer already replied by my senior friend, my lord. My submission for your lordship, my lord, is clearly, my lord, he is without silencing, my lord, the advertisement, which, my lord, he appeared. And, my lord, my appointment cannot be silenced, my lord. And by interpreting, my lord, clause 9, any interpretation required, my lord, there is a rule, my lord, then to have gone through that rule, and on the basis of that rule, they have disposed of their representative. My submission before your lordship, my lord, my appointment already, my lord, is confirmed, and it is by way of, my lord, I got first position, and my now appointment has been confirmed on 8/11/2020. This my adopted my land.
Right, please. So far as qualification, changing qualification, I have already changed. They kept the qualification as on first of the year, 1st of January. They could have changed it. General instruction of both the advertisement and also that date has remained the same. And I qualified in both the DPC. They called me for interview. So that itself says that I have the qualification. In any case, but I am a 5 year. I am senior to the private respondent by 6 years. And I had the and they, because of that date, that cutoff date of 1/1 of that particular year, 1st of January, clause 1 of general instructions, they cannot say. And the QPT guidelines also forbid them from doing. That is one part of. Then the second one, my lord, why he has been saying that I have no challenge. So the appellate authority, I do not, my lord, crystal clear from both the writ petitions, my lord. My prayer at page 20 of that second. And page 20. 937. Page 20 of the second writ petition, my lord, 3937 of.
recommendation of DPC.
Yes, ma'am. The lordship will kindly see. And not to set aside and quest, that is a prayer part. Not to set aside and quest the impugned letter under reference number so dated 9/6/23 and Annexure 7 issued by the registrar in charge, Indian Institute of Technology, Gauhati. So I challenge the order they passed on my appeal, which is annexed in Annexure 7, page 40. I just want to show something from page 48. Annexure 7. This is the reply they given on my appeal to me, madam. It reads, in response to your letter, that so addressed to the director officiating on the subject cited above, the undersigned was directed to informing the committee. Your appeal is under consideration in the office of the registrar. If any urgency citing the urgency should have approached the registrar church first before writing the official directorate in violation of clause 16 of the statute. Further, in your appeal to the registrar in judge for having somehow managed to
How
come
is it-
across the BOG's,
How is this relevant?
my lord,
Why relevant?
it is relevant because something concerning me, my lord, my selection, they do not update the or upload the website, my lord, and then they say, since I filed the appeal, so in the appeal to the officiating director, you have mentioned BOG's concern, my lord, kept as a secret document and not circulated. As per your letter, you have managed to come across the above referred confidential documents. Therefore, the undersigned is directed to complete details from you how we have managed to get the what is confidential about my result in taking part in the and it was their duty to upload it in the official website, which they have not done. I have annexed in annexure 8.
What is that? You're not seeking any orders from that respect.
Well, this has to go definitely, my lord. They have taken a stand against me, my lord, that I have, as if I have stolen something from their safe, my lord. When it concerns, my lord, my result, I say, my lord, in my appeal, I have said that I was already there in the top position that should have come to me. But if I had known, my lord, this possibility of inspection would have come in the first place.
If not completed, we'll come back again at PM. Please. Come back
If
at
your
2
lordship
PM.
seeks any clarification, I am ready to give, my lord. But I think, my lord, my earlier arguments are there. And, my lord, if your lordship really wants some concise, that also I can face my any concise, my lord.
It's for you to decide. We don't need any.
Yeah,
Definitely
I'll
you
just place it right now, my lord. Because conclude it, my lord, it's a long time.
But counsel for parties reserved.
And your lordship, at your lordship, the problem by the cancer and resources. Letter was issued, your lordship. Letter was issued on 17/3/2020. My representative, I have specifically mentioned that it's like to inform you that I am a cancer patient and I have been undergoing essential treatment. Secretary, your lordship.
Now, make say not covered under clause 7 of that notification. Clause 7 are the exceptions carved out. Yes.
Five.
Five.
Five means 90.
Five. Yes. Yes, correct.
Case of the.
Yes, that could be considered. Yes, that's correct. That was also. Considering the condition. That the petition received by the election commission, that can be taken care of. Then forwarding ballot will take, that will delay the process. That can also be done from the department. It will be forwarded, but since ballot the petition has been received by the election commission, on that basis also considering.
Five is.
Yes, that will be done, Malad. Yes, in terms of 5, that will be done. Correct, correct. Yes, correct. Yes. But that will be
Pass. Yes, order, either.
that will be forwarded. Correct. Here. Under 5, 5 is very clear. Under 5, Malad, the election commission will consider it. Verify. And give it 90. 11, yes, 11 party or find it 91. Para 5.
relatable to election. Suffice, madam. Secretary. Yes. Ninety.
Order.
Okay.
At the rate of 400 per month, and illegal deduction of ten against this by annexure R2, they have stated that there is excess amount is recovered from you. Annexure 4, is the affidavit in opposition.
Amount already recovered.
Is true. They have said that excess amount recovered. Now, I have not been paid. From my first pension. And they have
Why didn't you attempt to resolve this?
The problem is that his claim is sort of wants to take the benefit of a particular scheme as well as a prevailing practice. Initially, when the services were, his service were under the IOC, Oil India, then there was a scheme as per which he was entitled to a pension and a sum of rupees 400 per month was to be added to the component of pension. But thereafter, realizing that the market condition was not conducive, their interest, the Oil India of its own motion wanted to alleviate the provision so that a further sum can be added to the pension component. That a particular scheme was worked out, and it was in pursuance of that scheme, it was provided that regardless of the pension or the particular slab which the employee is down, they would be en bloc given an additional benefit. And the particular sum of 400 rupees, because which the petitioner is claiming, that was to be adjusted. Now, he took the benefit of that particular scheme, and after taking the benefit of the scheme, he now claims that he should also be given a further sum of 400 per month in his pension. The difficulty is that things do not go together. Either you take the benefit of the scheme, whatever pension is determined according to the scheme, you take the benefit of that, or you take the old the old rate at which the pensions were being paid. He wants both. Your Lordship will kindly see, he superannuated from service on 30th of April 2012. And he now says, by referring to a trust deed of the respondent company, that there was a promise made to pay a pension of rupees 400, I mean a component of rupees 400, the pension. The trust deed he has annexed at page 20. 16. Yes, it starts from 16. but he refers to the particular provision which your lordship will find at page. It refers to clause 14 of the deed. The lordship will find the clause 14 at page 29. Now, if you lordship, if I read from the top pillar, there is a chart given as to how the pension component is to be calculated. Now, this is the gradual progression at which pillar the pension will be determined depending on the monthly sum. Now, clause 14 says, notwithstanding anything to the contrary in these rules, the trustees may, in their absolute discretion, pay a pension for life to a former employee who has qualified for pension under the rules of the fund, and on his death to his widow or his widower, as the case may be, or pay pension under any other annuity schemes of LICI, provided always that the cost of the annuity policy providing for such a pension shall not in any event exceed the cost of the annuity policy providing for a pension payable for the life of such former employee. Now, clause 1, ad hoc relief shall be paid all the entitled pensioners who have retired and will be retiring up to so and so at the rate of 90% of the accumulated portion of the pension as one-time ad hoc relief, subject to a minimum of rupees 150 and maximum of rupees 400. He is fighting for this rupees 400. Now, these 400 is payable only when the pension is paid in pursuance of the scheme as explained here in the preceding paragraph. Now, over a course of time, it was found that the amount of pension that are being allowed to the employees that were falling short of the need, keeping in the view the rise in the market, the index of the and it was all done before the revision was effected in 2007. Now, considering those changes, they introduced the scheme in the year 2013. Now, that 13 scheme had said, your lordship will kindly come to it at page. My affidavit in opposition, page 10, your lordship will kindly see. This was in 2010, 22nd September. A revised scheme was brought out, and it was provided that as per the provisions made in this scheme, the new page 10, annexure R1, page 10 in my affidavit, yes, which was filed on 28th of April 2016. Now, this is where the revised scheme begins, and your lordships may kindly come to next page, the clause 4, in order to implement the aforesaid revised gracious.
What is the base?
Now, this is explained, Lord. The para 4 will explain it, Lord. The following modalities are laid down for the approval of the authorized committee of directors. The approved revised scheme has been made effective from so and so in lieu of the existing ex gratia scheme. Now, the ex gratia scheme that I have read out to your lordship at page 29 of the writ petition. In lieu of ex gratia scheme, which was approved by the board in meeting so and so, read in conjunction with the approval given on so and so, Therefore,
When did the petition
2012. And before his, yes, 34, 2012. And before his retirement, this change came, and he has not challenged the modalities prescribed here.
by this particular clause 4, done away with the explicit.
We have said that no, we have done away with it in a sense that 400 will be there. May I just give an example how to demonstrate it? Supposing a person is drawing a pension of 100 rupees, out of which rupees 40, maybe the 40 is the amount payable under the ex gratia. Now, keeping in the rise in the market, we have decided that no, he should be paid 1,500. Now, this 1,500 will take care of the 40 rupees he was already getting. So here this revised scheme says that you will be getting a higher pension, but this 400 that was to be paid to you under the previous scheme, that will be taken care of here. So to say that if I am providing you 1,500 rupees extra, that means you will be getting, in effect, you will be getting 1,100 rupees extra because the 400 will be taken care of and adjusted in the scheme in this manner. That right? Yes. Yes, earlier. So that way things were proceeding. Now he retired in the year 2012, and page 39 he was intimated about this. Page 39 of the writ petition. In reference to your letter dated so we have to state that the benefit of the ad hoc relief has been merged with that of the revised ex gratia introduced on 1st of August 2010. The revised ex gratia has been extended by OIL as an additional benefit to the pensioners of OIL Pension Fund over and above which is stipulated in the Oil India Pension Fund Trust Deed. And yes, now he claims that not only he should continue on getting what he has been getting now, he should also additionally get further sum of rupees 400. That is impermissible because you cannot have the cake and eat it too. That is the problem. And so far as his other limb of demand is that there was a deduction of some 4,000 rupees, some 4,000 rupees below. Only 4,000 rupees below. That was because the adjustments were being made when he retired. Now the pensions were calculated, and when making the adjustments below, there was an observation that some extra payment had been made, and therefore the deduction came. Now his pension was to be adjusted, was to be decided in the view of the revised scheme. So additional payments were made, keeping in 4,000 rupees. That additional payment was made because of a miscalculation, and therefore this deduction was made. Now, even if he says that deduction was illegally made or something, now that can be another limb of argument and another limb of relief. But so far as the main relief is concerned, that he should get the benefit of the annuity scheme under the trust deed, that is of 4,000 rupees ex gratia pay, as well as the benefit of the there, then this is not permitted. Yes. I know.
What my learned friend has made submit. I respectfully submit. Why? That they have stated that it is 400 already marked. My pension, where is the conclusion? They have not come up with anything that it has been marked. How it is marked? Now,
First tell us. Nice. Nice explicit key.
I know. Here, in number 11, what kindly tell you that if this page number 11 is read with the page number 39 of the writ petition, the entire picture is clear. Here, this I read out the page number 39 of the petition, where it is mentioned in reference to the letter dated 24/2014, to write that the benefit of an ad hoc relief has been merged with revised ex gratia introduced well from 1/8/2010. Revised ex gratia has been enhanced by well as additional benefit to the what is stipulated well in a pension fund trust deed, and trust which the benefit of ex-gratia has been enhanced with effect from 1/4/2013 by minimum benefit, citing the maximum total benefits all India consumer price index. So, my lord, their correspondence says that I have been paid. Where it is paid? That is why I have prayed. I have written several letters to them, to the authorities, that please provide me with why you have not made this payment. And ultimately, I had to come up before this honorable court.
There's no response to it.
No, they have given this thing. Only this annexure 6 is the, and they said that it is smart. Where it is smart? And regarding this access, adopted granted is that is 400. 400. Minimum is 150 and maximum is 400. That 400 is never paid. And it is their own bid. It is the bid clause number 14.1 and 14 specifically mentioned that ad hoc relief shall be paid at the same ratio as mentioned under in 14.1 the pensioners shall superannuate after 1/4/1989 and upon their attaining the superannuation. Those who will be retiring after 1/4/89, they will be entitled. So how I have been deprived from page number 29, what my learned friend said. 29, 14 of my petition. 14, Roman 2.
My lord, may kindly see the second paragraph. My friend has read only first paragraph of page 39. Lordships will kindly consider the second paragraph at page 39. May kindly be noted that while computing the pensionary benefits to the members of Oil India Pension Fund, the stated additional component of ad hoc relief has not been considered for any of the members who have superannuated after 31/3/2008. Meaning thereby, my lord, this 400 rupees which he is claiming, that is taken care of in the high. Now, either you take 400 or you take the if why he is asking for this, my lord. If your lordship will kindly refer to page 29. Page
First tell us.
he claims that there is a trust deed of the Oil India, which is annexed at page 29. I will start from 16, but reference is made page 29. Now the trust deed says that how the pension fund will be distributed to the employee. Now it gives out gives a table that from the age of when the person is of 47 years of age, from that his pension, his salary will be taken into account 25% of it, and that will be continued to be added to the corpus. Yes, corpus. Now, after the corpus comes, then there will be an addition of minimum 15 based on the money that is generated. There will be a minimum addition of 150 rupees or maximum addition of 400 rupees, and that will constitute the corpus that will go to him. Now, this is a fixed sum. It is not variable. But since the consumer price index is a variable component, it was a generosity of the respondent oil that they said that we'll give you a hike. We'll revise the pension scheme, give you a hike, but not this one. Now, this 400 is taken care of as it is says that this 400 is marked with the new hike. Now, if you are yes. So this 400, this is a fund created by us. We calculate the fund. suppose his salary, as I said before, suppose his salary is 1,000 rupees. So we assume that 25% of it is 250 rupees. So we contribute it to the fund. Now this way the fund is maintained. No, no, this is how we maintain the fund. The practice was that the fund that is generated, this used to be kept under an annuity scheme of LICA. Now, after the person retires, the LICI, the accumulated fund will be paid to the person by the LICI directly. That used to be the practice. But over a period of time, it was not working. So, and considering the market scenario, we thought that instead of following this formula, we'll be giving you because now if he proceeds on this, then he comes to a standstill. Because this is not variable. He comes to a the fixed sum of money. Now, keeping in mind the consumer price indexes and all, the revised scheme was introduced in the year 2010, saying that whatever is worked out, that is taken care of, and additionally you will be paying. So that's why I said, if I am paying you 1,500 rupees extra, then effectively you are getting 1,100 rupees extra, because 400 rupees is taken care of in this. He says that regardless of whatever hike you give me, I must also additionally get 400. That is the point.
Where have you demarcated this?
Now now we have filed an affidavit, my lord, to which there is no reply. And in our affidavit, my lord, we have given a table at page 20 to indicate how the things have been worked out in his case. Yes, that will be annexure R3. Now, here in the second table, your lordship will kindly see. Option single life with ROC with commutation, then 1/3 commutation paid through so-and-so account is this much. Then monthly pension is worked out as 15,208. Now, if his basic salary at the time of his retirement is taken into account, then it ought to have been calculated on the basis of the table at page 29. Page 29 gives a table that how the progression has to go, 25% at every year, from first year to 10th year. Now, it ought to have been taken care of in pursuance of, the mechanism displayed in page 29. But that has not been done. In the revised scheme, this has been worked out. Now, he says that no, I will also take the benefit of the revised scheme as also the benefit of extra 400 rupees. Your lordship,
The price index,
your
it should be
lordship,
much more than calculated as per the calculation.
your lordship, I'll take your lordship kindly to page 17. Page 17, clause 4, your lordship, you kindly see. The amounts of monthly ex gratia in the first year, that is the financial year 13-14, and corresponding monthly benefits for pensioners, be as under. Serial number 4. The amounts of monthly ex gratia in the first year. Yes, page 17 of the my affidavit. Clause 4. Roman 4. The amounts of monthly ex gratia in the first year, that is the financial year 2013-14, and corresponding monthly benefits for pensioners would be as under. Now, on the left hand side, your lordship will find the unionized and various grades of employees given. The monthly ex gratia in the first year linked to AICPI, that is All India Consumer Price Index. Now, this is the sum component. And in the second column, your lordship will find pension.
That the amount
Well,
the benefit is evident page number 17. chart. Because the pension is pension.
Yes, our case is that
In sum total becomes pension.
subtotal becomes expense.
So that, right, when he says, this
Benefit is because, my lord, I'm just explaining it this way.
see, in order to, calculate, yes, that is- that
Yes, I've got your lordship point. Look. What was the practice followed after the pay revision fee? The practice of adding that 400 rupees was altogether done away with. Only, as I said before, only thing is that it used to be taken as a figure merged into the final benefit granted under the revised scheme. Supposing your lordship will kindly have the page 33 of the petition. It is the exact replica of what I have stated in the page 17. Now, the past practice of adding the 400 rupees to the component, that was done away. Instead, this is the monthly component of ex gratia we are adding. Yeah, your lordship is basically base figure is his last drawn salary. Base figure is his last drawn salary. Yes, and on that level, he has also enclosed certain salary slips with the writ petition, based on which he wants to say. No,
pension
he has included a salary certificate, the salary sort of salary slip at page 15. Now, by showing this, he says that the 1/3 of the various components are discussed here. What will be special pay? What will be the basic and DAs and all? And based on it, he says that under the column ad hoc pension, there is nothing added. There is an endorsement ad hoc pension. Your lordship will see. That is G. He says that because under this 400 rupees is not added, so it becomes apparent that you have not added 400 rupees to my pension.
L is L. So L. You see ad hoc pension.
Yes.
It says G. That is 400 into L. L.
So that used to be the formula which was in practice previously. That the rupees 400 will be added. This was
added in L.
yes, the star.
Last one thing.
Maybe last one. My print was a bit distinct. I thought last.
It appears to be multiplied. L. L and D.
Star multiply.
Third salary.
B is basic pay.
B is basic pay.
B is basic
B
pay.
is pensionable salary, I think.
Yes.
Then C is 1/3. D is L.
On the top there is IC factor written. On the top, that's page 15. lordship will find left hand side just below the name of the petitioner. Yes. There is some factor which was to be employed here. All other things are abbreviations are otherwise traceable. But this is the factor. I may be allowed to file. That is only ground. Yes, that is the only ground. I'll explain the calculation in an affidavit. This payment, as the page 39 demonstrates, these 400 is marked with the, it is already taken care of in the revised scheme. Therefore, basically, my lord, as I understand it, yes, my lord, as I'm trying to understand it, my lord, basically, the lordship's query is, supposing this is the basic pay, add 400, it becomes this monthly pension. Now, and
Whichever way you explain.
yes, now this instead of this 400, you are adding something. Yes, but for that, my lord, I had shown your lordship the revised scheme. The revised scheme itself says that it is taken care of. Then, in case, my lord, if your lordship is taking that view, that it can be remanded.
No, we don't want.
Right. In that case, your lordship will accommodate me for a very short duration. Right? Any date in the first week of May? Some difficulty. 7. Ex gratia.
Ex gratia. Rights.
Appropriated in the revised pay
Pension.
pension scheme. Pension scheme. Your lordship is putting it as part heard.
Not part of.
So in that case, it will get some precedence in the list. That is it.
You mentioned it. Isn't it? guidelines?
Every warning, demand, displeasure issued in writing, not automatically kindly place the performance assessment report. Only cases in which despite such warning, etc., the officer has not improved, the appropriate mention of such warning, etc., may be made in the performance. First say that you have to be counseled or give warning before you. Then lordship may come to was 2.26. And the report neither contain any assessment pertaining to a period prior or subsequent to the reporting period, nor should the assessment be based on a single or isolated instance. The initiating as reporting officer has insufficient personal knowledge about an officer, he should not hesitate to say so and should not endorse the part of the report. The responsibility of the initiating officer to counsel and guide the officer as well as to apprise him of his shortcomings when noticed throughout the reporting period. This obligation of duty should not be deferred to the time of initiation of APR so that adverse remarks any do not come as surprise to the officer reported upon. To say that counseling method, again, Lordship may again come to clause 4.9 regarding the warning or counseling. That counseling or warning should be. Then another link is Lordship that
We are yet to find 4.9.
page number 94 of the guideline. Necessary that every government servant should know what his defects are and how to improve them. Every reporting officer should realize that it is the duty not only to make an objective assessment of his subordinates' work and qualities, but also to at all times the necessary advice, guidance, and assistance.
What happened in your case?
In my case, Lordship, the adverse remarks, Lordship may come to the adverse. Lordship, the second round is Lordship non-communicated. I have to also be not communicated. I am also on that also. For that, Lordship may come to page 92. Lordship, clause 4.
92.
92, clause 4. Regarding non-communicated.
That is
No,
okay. We want
Yes, yes. My case is Lordship. I have been Lordship. It adverse remark and is page 36. The adverse remark at page 36. Whether it's adverse or the advisory, they are not saying it's 36. Qualified radio operator is to be accompanied with colleagues and understand as well as realize their pain. Although it must be given his dedication and becomes worthy the right post, overall SO is very yes. Because of this remark, my promotion has been occurred. And Honorable Supreme Court they said when something is achieved that first affects his
where is the parameter that you have to be given outstanding 5 years?
that is not there. Very that parameter I have quoted. Outstanding that is not there. But because of this remark, they are stating that the affidavit is because of my this remark, they have been had and not similar cases.
Where in the evidence?
160. 160. Once it, penalty made time, it starts from the petitions. Business case was not recommended by the preliminary screening committee. Adverse remarks in the annual performance report for the year 2022-23 as per aforementioned policies. And that the April 36 that I have read, for the APR of 2020. Yes.
And why the guidelines?
Guideline has followed my lord. But the case of for promoting ASI to rank of for the vacancy of 2025, and that was made in October 2020. And my lord, his adverse mark was of 2023, and submitted presentation before my lord. It is of 2024, my lord. No, not the occupant code. As per my case number 74, my lord. Case number 74 can see the pay 1.25, my lord. If an officer fixes for promotion and selection for the appropriate appointment must necessarily be based on the annual performance assessment report and necessary for currently as an officer personally. Personal character and professional quality cannot be emphasized. The initiating reporting officer should endorse his opinion on an officer taking into consideration such a point at his own power, expression, staff, and administrative initiating reliability, judgment, and for the superior influence and the support. Has the power to give his opinion, madam. That in the APR.
Then it is saying that
Correct.
it is very good.
Very kindly see the word in 0.25, my lord.
What does wording mean? The report is the very good. That's the benchmark. It can be anything.
But,
It is very good. Then what is the take it wording without taking into account reading? You have to read it.
as per 74, my lord, there is 0.25. Yes, sir. It's 39. Oh, no, sorry.
36.
36. Oh, yes.
The
Yes.
description of the strengths and weaknesses or something like that. Strengths and lesser strengths. Reading required.
Five.
5 years. So what are you reading for the last 3 years?
All are outstanding and very, I have quoted it. There are
Very good.
therefore, it's a vague and without specific incidents, it's vague. No incident has been stated.
That is the incident pilot, this
Not on that incident, we are on the FKR, which is under consideration.
considered his promotion in 2.5 specifically stated, Malon, since an officer fixes for promotion and selection for appropriate effort and must necessarily be based on his annual performance assessment report. That is for grading, Malon. Then, Malon, the necessity for correct assessment of the officer
All
personal
these
indicator.
All these are principles, guidelines. See,
The colleague and understand as well as realize their pay force. Although the individual must be given his dedication and become what alike
yes, Rima, how reading is very
are on as we stated.
described in the reading.
That's
Why,
why-
why that
Yes, but as per the affidavit, madam,
the evidence, why is 5 years?
because of advice.
That was Rima. That was so it was
Have the same to the reporting.
See, that is the I have stated in my affidavit, madam, DPC proceeding, DPC, that is the
where is the DPC money?
আপনারা depicted by There is screening committee. Case number 165 minus number 160, paragraph number 80.
Okay.
160. Last portion
From
of
your
paragraph. Yes, last portion of paragraph number 18 minus.
So where is the preliminary screening? Some person who not has the screening.
That's it.
Why are you saying that was
That's the because of this. First, I have the thing. And my ground is that process. It is a logical pointed out right to the other they have not communicated also.
what concept? What the 18 by the taken by the preliminary.
Selling an order passed by CRPF authorities.
Very, very good.
We'll find it page 32. I Chicken dismissal service. Interfere. Union right, it is covered by 54A3. It's 32. 30. Page 23 stars, my lords. Page 28, penultimate paragraph, my lords.
23.
Page 23 it starts. Order dated 25/2016. Concluded page 28. Paragraphs, my lords. Service along all other components. That, my lord. Any to appeal. Page 20. Date, my lord. This. Then they passed this order dated 4/5/2019 at page 32, invoking FR 54. My case is, my lord, that I'm not covered under 50, FR 54, era 5, of the exception 5, extension 5. But it's a para point 5, go para 5, the sub 5, the case has to be covered under 4. FR 50, FR 50. 4, 5. For 5 minutes. In case falling under sub rule 4, that is the preceding, the period of absence from duty, including the period of suspension, preceding is dismissal, removal, or compulsory retirement, as the case may be, shall not be treated as a period spent on duty unless the competent authority specifically directs that it shall be treated so far for any specified purpose. Provided that if the government servant so desires, such authority may direct the period of absence from duty, including the period of suspension, preceding is dismissal, removal, or compulsory retirement, as the case may be, shall be converted into leave of any kind due and admissible to the government servant. But my lord, the rule 5 says that it specifically says it fall under rule 4, the preceding, above. Rule 4, my lord. Case other than those covered by sub-rule, including cases where order of dismissal, removal, or compulsory retirement from service is set aside by the appellate or reviewing authority solely on the ground of non-compliance with the requirements of clause 1 of clause 2 of Article 311 of the Constitution and no further inquiry is proposed to be held, the government servant shall, subject to provisions of sub-rules 5 and 7, shall be paid such amount of the pay and allowances to which he would have been entitled had he not been dismissed, removed, or compulsory retired, or suspended prior to such dismissal, removal, or compulsory retirement, as the case may be, as the competent authority may determine after giving notice to the government servant of the quantum proposed, and after considering the retention, if any, submitted by him in that connection within such period, bracket, which in no case shall exceed 60 days from the date on which the notice has been served, as may be specified in the notice. And the reading of paragraph 4 is rule 4 reveal that if the authorities on their own volition, if they set aside by dismissal, then rule 5 comes. But whereas I am covered under FR 54A3. It's not applicable because 54.4 says that dismissal or suspension is set aside by the authorities themselves. Then my lord, then rule 5 comes in. My case is different because court interfered. This is rule FR 54A3 for a moment. Dismissal, removal, or compulsory retirement of a government servant is set aside by the court on the merits of the case. The period intervening between the date of dismissal, removal, or compulsory retirement, including the period of suspension preceding such dismissal, removal, or compulsory retirement, as the case may be, and the date of reinstatement shall be treated as duty for all purposes, and he shall be paid the full pay and allowances for the period to which he would have been entitled had he not been dismissed, removed, or compulsory retired, or suspended prior to such dismissal, removal, or compulsory retirement, as the case may be. My case, my lords, there was an interference by the court of law on merits. So I am entitled to treated and on duty, and my entitlements has to be decided accordingly this rule. Page 28. Page 27. Yes, they hold it. They held it. I was awarded. Applicable because the penalty awarded next subsequent penalty was the reduction of cumulative increment for 1 year. No, madam, I'm at 54. I am covered by 54A3, my lord. I'm not covered by 54.4 because 54.4 reads 54 if the authorities on review or appeal. The authorities themselves, the higher authorities on a review by the delinquent or on a review, then 54.4 comes. Then because 5 clearly says which is 4, what will come under what. My case, minus I will reinstate it due to interference of the honorable court on merits. that penalty also, Malad, the other proceeding, Malad, there was a timeline. Initially, it was given, Malad, within 6 months. That was in the year 2016. Now, retail comes, retail adds another 3 months, totals to 9 months.
Where you reinstated without the further in. Merit.
Merit. The citizen. That is right. Madam, there is no further debate. Yes. Yes. Okay. My case is slightly on a different footing, madam, because I was awarded, subsequently I was awarded a penalty of a deduction of increment of 1 year. My case is that it deduct there also. 1 year increment deduct. Then also I am entitled to those back wages, that period. That period which you kept me under dismissal.
Mr. Roy, he won. See,
Because found guilty lawfully when it was charged, he has not annexed the order. After fresh inquiry, page 48, 84. My affidavit. May I read?
Final, my lord, final page 89.
89.
Penalty. Stoppage of increment for 1 year without cumulative pay.
Here, that suspension period also, that's why 54.5.
subsequent. Page 30,
My lord.
Yes.
page 32,
Ah.
immediate order.
Great.
Deference to the order.
I get it simple, manner. Since the penalty now turns to be punishable of one increment of 1 year, withhold 1 year. I'm not agreed by that. Withhold 1 year. But other those years I'm entitled to my. Hello, I have a case lawyer friend. Anandit Singh.
Set aside the entire DP law, without exonerating him from entire charge. Here, in this case, he was not totally exonerated, given us liberty to proceed de novo. In what he is citing, all the cases were exonerated.
But if you say
He put there in A1. No, if we are given 54, 5.
Five.
5. Look, may I read now? 54 times. In a case falling under sub-rule 4, the period of absence from the duty, including the period of suspension preceding his dismissal, removal, retirement, as the case may be, shall not be treated as period spent on duty, unless the competent authority specifically direct that it shall be so treated for specified purpose. Now, look, if he is falling under sub-rule 4, may I read?
other than those covered by sub-rule 2, including cases where the order of dismissal, removal, or compulsory retirement from service is set aside by the appellate or reviewing authority only on the ground of non-compliance with the requirement of clause of Article 311 of the Constitution, and no further inquiry is supposed to be held the government servant shall subject to the provision of sub-rule 6 and 7 be paid such proportion of the full pay and allowances which he would have been entitled had not been dismissed, removed, compulsory retired, or suspended prior to be such dismissal, removal, or compulsory retirement. With this whole then because no further inquiry is permitted. Within such period, which is no case shall exceed 60 days from the date on which the notice has been served as the may be specified in the notice, provided that any payment under the support the government servant other than the preceding that government servant who is governed by the provision of the payment of wages shall be restricted to the period of 3 years immediately the date of the order of reinstatement of such government servant are passed by the appellate authority or reviewing authority or immediately the date of the retirement on subordination of such government servant as the case. Subject to provisions of sub-rule 2 and 2 or 3C. Yes. Now, I was dismissed for a period of 2004 to 2019. I was reinstated. Now they further held a DP. Now they deduct an increment of 1 year. 1 year. I am okay with that. You deduct that also, but you pay me my back wages because Rule 54A, lordship is also subject. Lordship is subject to 54(3). Okay. Subject to rule sub-rule 2 and 3. Subject to the directions in any of the code.
One.
A1,
A1.
A1, when the dismissal, removal, or compulsory.
A1 is where the stated president, not you.
But my lord, then I also don't fall under 54, these 4. Then I have to stick back to my lord, the original order of the court, my lord, which happened. At page 28, it says,
Don't take that you shall be given in service with it.
are now, my lord, directly to court to reinstate the pension, making service relevant consequences. That period, my lord, back wages,
What does service mean?
that those wages, my lord, enrollments which I was entitled and my directly back. Consequences service benefits, my lord, my lord, because my batchmates now they have been promoted, my lord. I lost my promotions also. I am entitled to notional benefits, my lord.
Really say.
That is my notional benefits. Ladder of seniority, my lord. I should be treated at par with my batchmates who joined with me, my lord. Notional benefits. So I'm retiring on 30 of this month. Very clear, man. Even in the reappeal, my lord, there was no interference.
Back with you.
Yes.
You're asking back with you.
I may ask, my lord, but in lordship will examine, my lord, whether I am entitled to notional benefits, my lord, because I am entitled to notional benefits.
Benefits.
Back wages, my lord,
Notional benefits are
notional benefits, my lord, seniority. there, my lord. My batchmates were all promoted. I was left behind. First, my lord, the Diwali Guru was a case of also come to my rescue. Second. Good.
Some are just
Every matter of city, part two, where we can read part one, depending on the case. Part two, this is the next part two. The urgency. The urgency. Matter hearing, there will be interactions between council and right. There any trick?
there was an interim order that the petitioner's claim for the suit shall not be prejudiced. Now the APSC
somewhere मतलब
अच्छा,
I'm wait for me. Yes, Mr. Venus. Like it. Let us have a.
not only this Somaya done that, but public interest.
We are conscious of that.
Of me.
Have it on fifth of May, but we don't know whether. After
30th I can manage, but 28th, like difficulty for me.
and you want it on fifth.
Fifth is
Listing a matter, we can list it, but we can't guarantee that. we will take it. Okay. Not be listed as serial number one, but we mention that.